Labadiena, gerbiami seminaro dalyviai ir pranešėjai. Pradedame mūsų seminarą tema duomenų apsauga. Visų pirma, tai visų paprašysiu išsijungti mobiliuosius telefonus. Taip pat tiems asmenims, kuriems reikalingas vertimas, paprašysiu užsidėti ausines. Tai tada pakviesiu tarti notarų rūmų prezidentą Marių Stračkaitį, sveikinimo žodį pasakyti.
Labas rytas, gerbėmėjai mūsų svečiai ir seminaro dalyviai. Man džiugu šiandien pasveikinti visus jūs susirinkus į seminarą duomenų apsauga.
Ladies and gentlemen, it is a pleasure to welcome all of you at the seminar on data protection. The protection of data and personal privacy is especially topical in our society and on a global scale in general. This human right will gain more and more importance as more and more daily activities are transferred to a virtual space. The quarantine due to COVID-19 promoted a more rapid digitalization of society. Since the dissemination of information has never been so intense, it is more and more difficult to preserve privacy. This topic is especially important for notaries, as they collect and process personal data each day because of the type of work they do. Data protection is closely interrelated with professional secrecy, one of the most essential principles of notaries. The obligation to uphold this principle springs from the very nature of notary's profession, and the appropriate implementation is an essential precondition of notary activities. First and foremost, notaries preserve professional secrets in the interests of clients. The application of this strict principle is the guarantor of trust in notary. Thus, each notary must take responsibility to take care of data protection on the basis of professional secrecy, as well as on the basis of national and European legislation with the General Data Protection Regulation at its core. Notaries were always bound by the rules on secrecy of notarial acts. Therefore, the entry into force of the General Data Protection Regulation did not lead to radical changes in the activities of notaries. However, new requirements for the protection of personal data have to be implemented. This has become particularly relevant with the creation of the e-notary information system by the Lithuanian Chamber of Notaries and the use of the e-Notaras information system by notaries. The increasing number of cybercrime and cyber incidents, both in Lithuania and worldwide, calls for a particularly good assessment of information security risks and for due attention to cybersecurity. It should be noted that data protection is also a concern for notaries' customers. The level of knowledge is increasing, as can be seen from incoming inquiries concerning the processing of personal data. As data protection is a process, notaries regularly learn about the proper application of the GDPR and other legal provisions in their activities. This workshop was therefore organized to provide notaries with up-to-date knowledge on the protection of personal data. I wish all of you interesting seminar and productive work. Now I entrust the moderation of this seminar to the data protection officers of Lithuanian Chamber of Notaries, Sandra Ražanaitė and Ieva Mikaliukštytė.
Dėkoju notarų rūmų prezidentui už sveikinimo žodį ir dabar kviečiu sveikinimo žodį taip pat tarti šio projekto sumanytojo ES notariatų tarybos generalinį sekretorių Raulių Radoj. Prašau, gerbiamas Rauli.
Good morning, ladies and gentlemen.
Labas rytas, ponios ir ponai, gerbiamasis prezidentė Mariaus Stračkaitė, Lietuvos institucijų atstovai, profesoriai, lektoriai, kolegos. Šiandien man didelė garbė ir aš džiaugiuosi, turėdama šią galimybę pasveikinti Jūs ir kreiptis į Lietuvos notarus. Taip pat į kaimynus iš Latvijos, Estijos ir Lietuvos. Labai džiaugiuosi galėdamas grįžti į Jūsų nuostabią sostinę Vilnių, kuri šiomis dienomis yra balta, baltai pasipuošusi ir būti kartu su kolegomis iš Lietuvos notarų rūmų. Šiandien ES notarų taryba yra labai svarbi diena, nes oficialiai pradedame veiklą skirtą notarams. Pagal mūsų mokymo programą norėčiau padėkoti Marijui Stračkaičiui ir jo komandai už asmeninį ir profesinį įsipareigojimą organizuojančiai pirmąjį seminarą Lietuvoje, mūsų Europos dalyje, jeigu galėčiau tai pasakyti. Norėčiau keletą žodžių pasakyti apie projektą ir jo kontekstą. L@N yra sutrumpinimas pavadinimo ES teisė notarams, notarai ES teisėjai. Ir ši ES notarų tarybos programa yra skirta notarams ir finansuojama iš ES. Projekto vertė yra 600 000 eurų. Ir 90% remia Europos komisija, o 10% skiria ES notarų taryba. O kaip žinote, ES notarų tarybos biudžetas susideda iš narių įnašų ir tas biudžetas susidaro iš jūsų įnašų, taigi mes esame už tai labai dėkingi. Įgyvendindami šiuos projektus per pastarosius 10 metų laimėjome, per 6 metus laimėjome 10 tokių projektų ir mes stengiamės platinti savo priemonės, kad notarai galėtų jomis pasinaudoti, kad mes siūlome priemonės ir remiame notarus jiems vykdant savo veiklą su užsienio elementu. L@Net seminaras skirtas 10 šalių – Lietuvai, Graikijai, Vokietijai, Prancūzijai, Italijai, Niderlandams, Portugalijai, Slovenijai, Maltai ir Austrijai. Kiti projektai, tokie kaip Europos notarų tinklas ir kai kurie iš jūsų tikrai žinote apie tai, juose yra daugybė informacijos apie ES teisę ir užsienio teisę susijusią su notarų veikla dėl šeimos teisės, įmonių teisės, paveldėjimo teisės, pažeidžiamų asmenų, nepilnamečių apsaugos dėl oficialių teisinių reikalavimų dokumentams ir įgaliojimams. Mes kviečiame jūs apsilankyti šioje atnaujintoje interneto svetainėje Notaries of Europe ir pasinaudoti šiomis priemonėmis. Jos yra pateiktos įvairiomis kalbomis ir visomis kalbomis yra informacija, visomis ES kalbomis, tame tarpe ir lietuviškai, ir lenkiškai, ir estiškai. L@Net yra 4. ES notarų tarybos mokymo projektas, programa. Mes turėjome ankstesnės 3 programas, irgi su pavadinimu Europo notarams, notarai Europai. Ir padedami komisijos per 8 metus, nuo 13 iki 2020, mes apmokėme 5000 notarų iš visų 22 ES valstybių narių. Ir tai sudaro nuo 11 iki 12,5% visų notarų praktikuojančių Europoje. Manome, kad tai yra didžiulis indėlis siekiant ES tikslų, kalbant apie mokymus teisinėje srityje. Ankstesnėse programuose mes surengėme 45 tarp valstybinius seminarus ir juose dalyvavo daug notarų, mokėsi apie šeimos teisę, paveldėjimo teisę ir vienas seminaras, prisimenu, vienas iš tų 9 seminarų, kurie buvo suorganizuoti, jis buvo čia Lietuvoje, tai jo tema buvo kova su pinigų plovimu ir regis prieš keliarius metus šis projektas buvo vykdomas. L@N projektas Europos teisė notarams, notarai Europos teisėjai. Tai mes ketiname rengti 10 interaktyvų praktinių seminarų, 10 temų. Vienas iš jų yra duomenų apsaugos srityje, taip pat šeimos teisės ir įmonių teisės srityje. Anksčiau mes susitelkdavome į asmeninius seminarus, gyvus seminarus, bet dabar, kadangi naujos sąlygos, pandemija ir Kadangi notarams galbūt lengviau dalyvauti mokymuose internetu, tai mes nutarėme sukurti e-mokymosi platformą notarams. Ir todėl mūsų pavadinime yra ETA ženkliukas. Tai yra elektroninių mokymosi platforma, kurią mes ketiname sukurti. Be paminėtų temų, duomenų apsaugos, šeimos teisės ir įmonių teisės, tai mes tikimės, kad su komisijos ir mūsų narių parama mes įtrauksime dar daugiau temų. O dabar mes tik pradedame kurti tą programą Briuselyje, kad visi ES šalių notarai galėtų ją naudotis. Ir tie buvo profesoriai, ekspertai, sukūrė metodiką šiems seminarams ir kai kurie iš jų šiandien skaitys pranešimus. Mes mokymosi platformoje turime daug įvairių pavyzdžių, vaizdo medžiagos iš seminarų. Mes taip pat stengiamės užtikrinti, kad visi ES šalių notarai puikiai galėtų taikyti įstatymus. Mes suprantame, kad yra nauja teisinio mokymosi strategija ir kiekvienais metais siekiam apmokyti kiekviena šalyje 30% notarų ES teisės aktų srityje nuo dabar iki 2025 metų. Tikslas yra labai ambicingas, nes iki šiol tik tai 25% notarų galėjo dalyvauti tokiuose mokymuose ES ir nacionaliniu lygmeniu. Na, o dabar mūsų tikslas yra apmokyti 30% notarų ir tikimės su savo nariais pasiekti šio tikslo. Ir reikėtų paminėti, kad iš tų 2012 metais buvo kalbama, kad labai svarbu mokymas teisinėje srityje. Ir taigi tokia yra ES komisijos pozicija ir mes tokiu būdu tikimės pasiekti tikslą apmokyti 30% notarų. Esame įsitikinę, kad Lietuvos notarų rūmai lengvai pasieks šį tikslą. Norėčiau mūsų organizacijos vardu padėkoti kolegoms, kurie prisidėjo prie šio seminaro rengimo, taip pat visiems, kurie šiandien skaitys pranešimus dėl duomenų apsaugos nuostatų, nes tai yra labai svarbus dalykas mums ir profesinė prasme, ir asmeninė. Puiku, kad ES notarų taryba su mumis ir galiu tik pasakyti prezidentui Marijui Straskaičiui, kad mes Briuselyje labai laukiame dirbti su jumis 2024 metais, kai Lietuvos notarų rūmai perims pirmininkavimą ES notarų taryboje. Ačiū jums visiems ir linkiu gerų mokymų.
Dėkoju ES notariatų tarybos generaliniam sekretoriui už sveikinimo žodį. Ir kviečiu jūs pažiūrėti trumpą informacinį ES notariatų tarybos parengtą video reportažą duomenų apsaugos tema.
Le règlement général sur la protection des données, le RGPD, est entré en application le 25 mai 2018. Depuis, les interrogations suscitées ont été nombreuses. Comment garantir le respect du principe de responsabilité accrue du notaire ou de ses fournisseurs informatiques? Par quels moyens démontrer que les mesures techniques et organisationnelles de protection des données sont adéquates? Le notaire est-il concerné par le droit à l'oubli? Doit-il désigner un délégué à la protection des données? Enfin, qu'est-ce que l'obligation de notification en cas de violation de données à caractère personnel?
L'approche du RGPD relative à la mise en conformité aux préceptes en matière de protection des données et à la vérification de cette conformité a fortement évolué. Le notaire doit apporter la preuve du respect des obligations du RGPD, ce qui lui impose de documenter les mesures de protection et de sécurisation des données qu'il met en place au sein de son étude. Il doit notamment élaborer et actualiser du registre des traitements de données à caractère personnel. À cette occasion, il doit se poser les questions nécessaires afin de s'assurer que les mesures qu'il décrit dans sa documentation sont bien implémentées, tant au niveau technique qu'au sein de son organisation. Par la désignation d'un DPO, il facilite la mise en place et la révision des mesures identifiées.
Notons que les autorités nationales de protection des données peuvent prononcer des amendes administratives pouvant s'élever jusqu'à 20 millions d'euros ou 4% du chiffre d'affaires annuel du responsable de traitement. Ces éléments s'ajoutent à une responsabilité déjà lourde pénale qui pèse sur le notaire dans le cadre des traitements qu'il effectue. À ce risque, nous pouvons également ajouter la possibilité d'une action collective.
By the very nature of their profession, notaries are among the largest collectors of personal data. In order to guarantee the legal security of transactions and instruments whose authenticity they ensure, they collect a considerable amount of personal data on a daily basis. Through exercising a form of public authority, notaries have access to various sources of official and authentic data which are strictly regulated by national laws. Furthermore, in order to simplify administration, the data collected by notaries is transmitted to and from administrations via secure IT systems which, in some European countries, enable signing of electronic authentic instruments, the electronic registration, electronic filing of company deeds, notification of certain transactions to social and tax administrations for collection purposes, etc. For several years now, notaries have been subject to strict obligations in terms of data protection, but also in terms of information security. At ethical level, the rules on personal data protection reinforce and complement the existing rules on professional secrecy and the duty of discretion. The various measures adopted by the notarial profession at national level are part of an international approach followed within the European Union. For example, it is not surprising to learn that different notarial professions, such as Belgian notaries, have a code of conduct for firms regarding GDPR, or that French notarial firms have benefited from the concept of a shared data protection officer within the French notarial profession for over 10 years. The GDPR has not broken from the system under the old directive that it has replaced and has not distorted it. Instead, it has taken up its principles and strengthened its foundations. It should be seen as a genuine and positive development of privacy and personal data protection rules. It contributes to strengthening the confidence of EU citizens in processing of their personal data.
Taigi visiems dalyviams, dalyvaujantiems seminare, dar priminsiu, kad seminaras vyksta tiek fiziniu, tiek nuotoliniu būdu video konferencijų platformoje Zoom. Kviesime aktyviai dalyvauti visus dalyvius, tiek esančius čia, tiek nuotoliniu būdu, kurie visada gali replikuoti Zoom pokalbių skiltyje. Čia esantys stalai yra sunumeruoti ir kiekvienas stalas turi savo mikrofoną. Tad aptariant užduotis, kiekvienas norintis galės pasisakyti. Šiame seminare dalyvauja Austrijos, Belgijos, Italijos, Lietuvos, Latvijos, Estijos, Lenkijos, Portugalijos, Prancūzijos ir Vokietijos notariatų atstovai. Seminaras yra įrašomas, verčiamas sinchroniniu vertimu į anglų ir lietuvių kalbas, o jo tiesioginė transliacija vyksta Lietuvos notarų rūmų paskyrose, Facebook ir YouTube kanaluose. Visiems seminaro dalyviams, nesvarbu kokia forma jie dalyvauja, bus išduotas dalyvavimą patvirtinantis pažymėjimas, o Lietuvos notarams ir kandidatams į notarus asesoriams bus skiriami kvalifikacijos kėlimo balai. Tad gal pradėkime mūsų pranešimų sesiją. Įvada į asmens duomenų apsaugą Jos ištakas ir svarbą notariatui pristatys pranešėja Aurélie Merkel, ES notariatų tarybos duomenų apsaugos darbo grupės koprezidentė, Prancūzijos notarė.
Okay, good morning. Thank you
Labą dieną,
for your
labas rytas.
invitation
Ačiū už
to
kvietimą
intervene in
dalyvauti
the introduction
šiame
of
seminare.
this seminar.
Ir ypač už tai,
I
kad
have
aš
been
darau
lending
įžanginę kalbą.
for 10 years
Jau
the mutualized
10
GP of the French notary
metų Prancūzijoje dirbu su
because
BDAR
French law
ir
established the
Prancūzijoje
IT
yra
correspondence
atskiras
and
įstatymas,
freedoms
kuris
in
numato
2005.
dar 2005 metais buvo priimtas ir saugo duomenis.
The European Union with my Belgian counterpart,
Kartu su Aurélie van der Part iš Belgijos 2017-aisiais dirbau kuriant dabartinę tvarką ir noriu pastebėti, kad Lietuvos notarai dar nuo mūsų tinklo įsteigimo labai aktyviai dalyvavo mūsų darbo grupėje duomenų apsauga. Visų pirma, pakalbėsiu apie duomenų apsaugos istoriją, pasigilinsiu į ją. Duomenų apsauga tai tema, kuri buvo plačiai Europoje aptariama ir visame pasaulyje. Ir šis klausimas yra senesnis negu BDAR priėmimas. 1948-aisiais mintis apie duomenų apsaugą atsiranda Visuotinėje žmogaus teisių deklaracijoje, 12 straipsnėje, kur numatyta, kad visi turi teisę į duomenų apsaugą, privačių ir šeimos duomenų bei korespondencijos apsaugą. 1995-aisiais taip pat ir buvo Europos žmogaus teisių konvencijoje numatyta, kad visi turi teisę į šeimos, privataus gyvenimo, korespondencijos apsaugą. Prancūzija, Vokietija buvo vienos iš pirmųjų valstybių per praeito amžiaus 80-metyje priėmusios įstatymus dėl duomenų apsaugos. 1925 m. ES direktyvoje dėl duomenų apsaugos tvarkymo buvo išplėsta piliečių apsauga ir jų pagrindinė teisė į privataus gyvenimo apsaugą. Šis tekstas pripažino didėjančią nacionalinę ir tarptautinę asmens duomenų apsaugos teisę. Taigi, 1981 metų konvencija įkvėpė ir ES direktyvą, kuri priimta 1995 metais. 1995 metų ES direktyva dėl asmens duomenų apsaugos buvo priimta ir ji paskatino daugelį šalių narių įvesti nacionalinius teisės aktus apsaugančius asmens duomenis. Ypač šitas šalis, kuriuose dar nebuvo tokių teisės aktų. ES direktyvas vienodina šalių narių standartus, numatančius asmens duomenų apsaugą. Direktyvoje numatyti 3 principai – proporcingumo principas, skaidrumo principas ir pateisinama priežastis. Tai buvo Europos duomenų apsaugos pagrindinis dokumentas.
sorry, 2018.
2008-aisiais, gegužės 25 dieną, buvo priimtas BDR. Prieš tai buvo net 4 metai, kurios truko dėrybos. Buvo pasiūlyta 40 000 pataisų. Daugiau nei 40 BDR straipsnių palieka valstybėms narėms laisvę rinktis ir pačioms priimti sprendimus dėl duomenų apsaugos. Atsižvelgiant į naujas informacinės technologijas ir siekiant išplėsti konvencijos 81 konvencijos taikymą, buvo priimtas tas BDR reglamentas ir Lietuva pasirašė prieš 22 metus konvenciją. 21 metų birželio 4 dieną Europos komisija priėmė naujus kovos su terorizmu veiksmus dėl asmens duomenų perdavimo trečiajai šaliai, pakeisdama esamas versijas. Šie nauji kovos su terorizmu veiksmai buvo paskelbti oficialiame leidinyje ir jais remiasi ir ES teisingumo teismas, priimdamas savo sprendimus bylose. Kokie iššūkiai kyla ir kas svarbu, kalbant apie BDR ir duomenų apsaugą? BDR, kaip suprantate, atsirado ne tuščioje vietoje. Prieš tai jau buvo tam tikra direktyva, tiesiog ją reikėjo pataisyti ir atsižvelgti į naujus pokyčius. Taip pat reikėjo įvardinti konkrečias teisės ir pareigas. Pereinant nuo direktyvos prie reglamento, teko atsižvelgti į naujasias sąlygas, stiprinti asmenų teises ir teisinį pagrindą leidžiantį saugoti duomenis. Taip pat buvo siekiama didinti ES konkurencingumą, ekonominį saugumą, apsaugą nuo kibernetinių išpuolių. Šiuo metu priežiūros institucijos yra įsteigtos tam, kad būtų informuojamos apie visus pažeidimus ir tai labai svarbu atskaitomybei užtikrinti. Privaloma registruoti visas operacijas susijusias su duomenų tvarkymu ir registruoti visus duomenų tvarkymo pažeidimus, visus asmens duomenų apsaugos pažeidimus.
At the initiative of the State Data Protection Inspectorate in the end of 2021, the company Spinter Tyrimai carried out a representative survey of Lithuanian residents focused on the protection of personal data. The survey results revealed that Lithuanian society cares about personal data protection. The inhabitants generally believe that their employers comply with personal data requirements, and more than half of the population feels that companies and institutions ensure due protection of personal data. A large proportion of the poll, namely 70%, are aware of the GDPR as the key link. As many as 43% of the survey participants are aware of their rights in the area of personal data protection. Respondents with high education and higher incomes, as well as residents of metropolitan areas, are more likely to be aware of their rights in the area. A mere quarter of the poll claim having not known about their right to protection of personal data. A total of 13% of the respondents report having experiencing unlawful of inappropriate processing of their personal data in 2021, while 68% believe they have not faced any breaches. I arrived on the field of application of the GDPR. The scope of the GDPR is particularly broad. From a material point of view, it applies to the processing of personal data, whether automated or not. Therefore, from the moment when a transaction is carried out on the personal data of a natural person, the GDPR applies. Whether this data is digital or in paper format, whether or not it is public. This may involve any operation, the collection, recording, transfer, or deletion of personal data. So reading data is a processing of personal data. This may involve any operation. Data concerned are paper, digital, automated, or non-automated. Exceptions are provided for example, in the context of a purely personal or domestic activity, private directories, correspondence exchanges, social networks, personal websites and blogs, unrelated to a professional or commercial activity. The GDPR not applied to the processing of data concerned by the prevention and detection of criminal offenses. Certain activities fall outside the scope of UE law, such as activities relating to national security. Processing operations carried out by the member states in the framework of their EU common foreign and security policy. From a territorial point of view, the GDPR applies to the processing of data carried out in the context of the activity of an establishment of the controller or processor in the territory of the Union, irrespective of whether or not the processing takes place in the Union. The criterion of establishment applies. For example, a Lithuanian company providing its services in Europe will be subject to regulation following for example, Vinted, following the receipt of a significant number of complaints concerning the online sales site of Vinted.com clauses managed by a Lithuanian company. The data protection authorities in France, Lithuania, and Poland decided to cooperate to monitor the site's compliance with GDPR. The criterion of targeting is added of this criterion. This means that the regulation applies to a manager of subcontractor who is not established in the territory of the Union, where those activities target a citizen residing in the territory of Union. The criterion applies when offering services to data subjects in the processing of their data. It also applies where the purpose is to monitor the behavior of the data subject. Monitoring of behavior, natural persons are monitored on the internet. Techniques such as profiling of a natural person to make decisions concerning them or to analyze or predict their preferences, behaviors, and mindsets. First, the GDPR will apply to the US search engine or to a Chinese sales platform for offers or targeting citizens residing in the UAE. It is also referred to as residence criterion, as European citizenship is not necessary for the application of the GDPR. In conclusion, the scope of application is therefore very protective in the same way as consumer law. Let us not forget that the aim of the GDPR is to restore citizens' trust and also to foster the free flow of data. Data Governance Act will soon complement this ambition. I will finish my introduction with explain the sanctions for non-compliance. Two levels of fines are possible. It depends of the seriously of the breach. 10 million or 2% of company turnover are punished the non-compliance, and 4%, sorry, and 20 million euros for non-compliance with general principles. For example, general principle for transfers, individual rights, transfers, national law, or injunction of supervisory authorities. Class action are possible today to have right to compensation in civil and or administrative courts. For example, class actions against Google or Amazon are faced to several supervisory authorities in France. In France, the CNIL decision of the 7th December 2020 imposed a total fine of 100 million on Google LLC and Google Ireland Limited. The added value of compliance in relation of the image are very important. Data is as the heart of the concept of trust. Citizens are concerned about the protection of their data. The use of the data makes it possible to provide the high personalization of the advice expected of our clients. Nevertheless, the general public sensitivity to data protection and the need for security are growing strongly. People build up skills. In a more digital environment, data becomes an important element of the customer's relationships, and its volume explodes. The development of new technology, like big data, data visualization, enables companies to develop new services, better manage risk, and improve their operational efficiency. And protecting the image is, of course, very important with data protection. To summarize, why do we comply? The benefit of the four pillars of the GDPR are trust, efficiency, innovation, and security, which are also reflected in the values of the GDPR. Trust is reassuring customers and clients and or patients, members, users, prospecting collaborators by promoting a foundation of fruitful and balanced commercial relations. It is a contract of trust induced by the GDPR. Efficiency, the optimization of their effectiveness, both commercial and organizational, with cost optimization, organization fluidity. Innovation, compliance allows the emergence of new services around the GDPR. And data security means improving the security of the entities' information heritage. So I thank you for listening, and I now yield the floor of the next speaker. Thank you very much.
Dėkoju gerbiamai Aurelijai
I would like
už jos
to
įvadinį
thank
pranešimą. Ir
Madam
nieko
Merkiol
nelaukdami
for her
pereiname prie
presentation.
kitos
Without further ado,
šios mūsų dienos temos
let's move on
asmens
to the
duomenų
next
apsaugos
topic
pagrindiniai
of our
principai ir
seminar,
veiklos
which is data
aktualijas,
protection,
apie kurias
the
mus informuos
fundamentals.
pranešėja
And now I will
Danguolė
give a floor to Madam Morkūnienė. She is Deputy Director of the State Data Protection Inspectorate.
Gerbiama Danguolė, jeigu jūs prie mūsų jau esate
Madam
prisijungusi.
Morkūnienė, the floor is yours.
Labą dieną visiems, tikiuosi mane matote ir girdite.
Good morning, everyone. I hope
Tai
you can see me
jau pat
well and hear me
pasidalinsiu
well.
skaidrėmis.
I'm going to share my slides in a minute.
Sakykit, viskas gerai. Tai labą dieną visiems dar kartelį. Tikiuosi mane gerai matote.
Good morning, everyone. I hope you can hear me well and see me well. Today, I would like to thank the Lithuanian Chamber of Notaries for this opportunity to give the presentation. Indeed, we hear a lot in the public space, and we are all people. And today I would like to speak on behalf of the Data Protection Supervisory Authority. What is important for notaries, the interpreter excuses the sound is unacceptable. Indeed, we have talked a lot about different aspects and threats. In general, cooperation is very important. Today, at this event, I see representatives from other countries as well as therefore, I would like to say that the Data Protection Inspectorate is cooperating with the authorities of data protection from other countries. We are exchanging information, we are exchanging the best practice. A lot of things are going on. The person speaking about me talked about the Convention of Data Protection. The data protection standards are really hard, and it is a positive thing because it changes our own point of view without narrowing it down to the rights. The free data movement is important because we live in a global world. It is extremely hard for interpreters to interpret this quality of sound. I do apologize.
Due to poor quality, interpretation is unavailable.
Tai Lietuvoje tikrai jų turime, kaip ir kitose šalyse, be galo daug. Pati valstybinė duomenų apsaugos inspekcija kaip pagrindinius teisės aktus savo veikloje tai tikrai taiko asmens duomenų teisinės apsaugos įstatymą, taip vadinamąjį teisėsaugos, tada tai kibernetinio saugumo įstatymą, elektroninių ryšių įstatymą, valstybės informacinių išteklių valdymo įstatymą. Ir tai yra tik tai ta kepurė, turime daugybę poįstatyminių teisės aktų, ne viskas ir turi būti reglamentuojama įstatymais, bet kad ta sistema veiktų, tai iš tiesų turėtų ir būti priežiūra. Atitinkamai, manau, nebe priežasties ES pagrindinių teisių hartijoje, minint teisę į asmens duomenų apsaugą, yra paminėta, kad visgi tai yra nepriklausoma institucija kontroliuoja, kaip laikomasi šių taisyklių. Tai mes turime tam tikrą raidą Lietuvoje. Anksčiau mes gynėme teisę į privataus gyvenimo neliečiamumą, kuri paminėta Lietuvos Respublikos konstitucijoje. Reglamentas įtvirtina teisę į asmens duomenų apsaugą. Tai turime ir tą momentą. Tai iš tiesų tų teisių yra be galo daug, bet mes šiandien kalbame apie notariatą kaip tokį, tai notarai neabejotinai turi daugybę savo veiklos ir srities teisės aktų, kurie reglamentuoja asmens duomenų tvarkymą. Bet iššūkių aš tikiu, kad yra pakankamai daug, nes yra nemažai teisės aktų, kurie palieka laisvės tam tikram įgyvendinimui, taip pavadinkime, tai iš tiesų yra tas momentas.
Dabar galiu? Aš labai dar kartą atsiprašau mūsų gerbiamos pranešėjos Danguolės Morkūnienės.
I'm really sorry to say, but due to technical problems, we can't hear you well. Would it be possible for you to disconnect and connect once again? I'll do that.
Kol mes laukiame, kol prie mūsų prisijungs mūsų pranešėja,
While we wait for
tai visų dalyvių, kurie fiziškai čia su mumis dabar dalyvauja, maloniai paprašysiu užpildyti seminaro vertinimo anketas ir jas palikti
fill in the assessment questionnaire of the seminar, and then when you leave the seminar, please leave this questionnaire filled in on the table. I will also ask all remote participants to do that, and could you please email it to the Chamber of Notaries. Thank you. Can you hear me well? Now it seems a little bit better. I hope it's going to be better, so I'll share my slides once again. Yes, we can see the slides well. Do you see my slides now? Yes, we do. Thank you. I hope it's better now. Yes, indeed. It seems better. Thank you. Now, I will continue. I will not start over from the beginning. Without any doubt, we encounter cases when legal actions depend on the data processor, on how these provisions are implemented. Therefore, there are certain risks to violate the principle of minimization of data. This regulation has changed the attitude towards the data protection. However, before you start processing data, it's you who have to take the decision and not the data protection inspectorate. Speaking of professions like notaries or attorneys, There are many general regulations that have to be applied. However, individual regulations have to be set up as well.
Na, toksai, žinot, kaip pasakyt, labai dažnai bandoma sakyti kliūtis ar trukdis.
Quite often we refer to obstacles, but I regard them as opportunities. The regulation in itself is not an obstacle. It provides us with an opportunity to work transparently and to process the data appropriately. There are a number of purposes for which the data is processed. Sometimes they are defined and sometimes they are not, and there's an extensive freedom to set the purposes of data protection. And you are going to speak a lot today on what has to be managed and ensured in your activities. However, the goals are separate, and accountability is an overarching concept which is understood in a very broad sense. There are a number of tools that can be applied for its implementation. And there are also certain obligations to provide the information to the Data Protection Inspectorate. You, as data processors, have to have a desire to establish certain procedures for documentation, different standards. And we are going to speak also about the rights of the data subject. And it is a positive development when the information provided to the data subjects are standardized. The scope of data processing may be different. Sometimes there's a question whether the principle of data minimization is not breached. The question is whether the data is not superfluous. Certain data processors may uphold one standard, however, another may aim for higher standards and manage additional risks. This is not bad, however, it is very good to have a certain agreement within the same sector. And data protection is a thing related to values. From time to time, the processes have to be reviewed. Data protection is not a one-time action. When we start applying the process, we have to do it until the end. There's a myth that data protection regulation is applied only to automated data, but this is not the case. This regulation is applied to systemic files, to all the documents. And you, notaries, you have the cases of clients, you have a certain system for these documents, and the regulation is applied in your case in a broader sense. Today, it has been said that the data protection officer has to ensure the appropriate standard for data protection. And I have mentioned that a competent data protection officer is very important to have. Therefore, the data processor has to invest in having these people, allowing them to be trained and to learn on a continuous basis. and this ensures the better quality of pieces of legislations within the organization, on allowing better access to personal data. A competent data protection officer allows managing the risks. In Lithuania, we have 2,746 data protection officers. It's up to you to decide whether the number is high or low, but I think that this is a good beginning. This number is increasing. For example, in 2021, we have 265, about the availability of 265 new data protection officers. Different public and private organizations assess the added value of having a data protection officer, because there is an additional value of having such a specialist. And certainly on condition that this person is really learning and is not only a formality. Having a data protection officer who has no opportunities to learn and who is not included into the data protection processes or planning reforms is not a good thing. The value of data protection officer depends on the company. So it depends on the management of the company, to whom the data protection officer is accountable. We learn from practice that the organizations that dedicate more time and effort to having qualified data protection officers have fewer mistakes, they have fewer problems in communication with data subjects, and they have a stable process ensuring the application of the General Data Protection Regulation. This process is continuous. If 5 years ago certain procedures were good and meeting the standard, they may be outdated today. The data protection officer alone can do nothing. The entire organization has to contribute in providing the information and support from the highest management of the company. What is the role of the Data Protection Inspectorate and Data Protection Officer? I would say that this is a two-way street, because the State Data Protection Inspectorate communicates via data protection officers if companies have them. This way, some time is saved. Otherwise, when a company doesn't have data protection officer, then the company has to learn different things in order to reply to the Data Protection Inspectorate's requests. In certain cases, we still have to prove that data processing includes as operation as simple as making a search. Of course, a lot depends on organizations themselves. I am happy to be able to give a presentation at the event of the Chamber of Notaries of Lithuania, because we have a lot of inquiries from notaries, and these inquiries are of a very high standard. they face us with specific questions, specific insights. Normally, notaries address our inspectorate when they face specific problems, and they already have in mind certain solutions for these problems, which is a very high level of inquiries. This is very important, and probably I don't have to talk about the personal data to such professionals as notaries. Other supervisory authorities face similar problems. Lawyers demand replies of a very high standard. Regarding data processing, I would like to draw your attention to very important aspects. Before processing any data, we have to know about the scope and the purpose. We have to know what we're going to do with the data, and this information on the information on the slide cannot be separated from the data protection principles. The scope of data protection is interrelated with the principle of secrecy. It is very good that you pose questions. Sometimes there are more answers to questions. Well, unfortunately, we cannot see the slides that you are talking about. Could you please solve this problem? Thank you. I'm very sorry. I'm trying to address the problem. Well, in order not to delay, I will continue. For me, the slides are moving. They are moving on my screen, but I cannot see why they are not moving on your screen. Yes, let's continue. Before starting any data processing, we have to think how things are going to develop. But when we want to change the existing data processing procedures, quite often we think that all the issues have been addressed in the past, but this is not the case. Any change in the data processing can have huge consequences for entire data processing, and it may predetermine the possibility of such data protection being unacceptable. Therefore, we have to check the earlier rules and make sure that nothing has changed. All of these questions can be answered by the data protection officers. I have a lot of experience with data protection officers, and quite often a data protection officer is assigned in one area and then all other employees help. This is the case in the law enforcement authorities. Well, it's hard to say whether this system is good or bad. It is not my duty to assess it. But we see the result, which is positive. Public sector has a possibility to hire one data protection officer for a few organizations. There are many ways and many tools ensuring transparent activities. I would like to draw your attention to topicalities in general in Lithuania. You have probably heard that in the near future we will have public consultations on the law of personal data protection and the regulation of the data protection. Regarding additional regulation, as you know, the regulation, the EU regulation, covers a lot of aspects, such as the limitation of data subject rights and data processing with scientific and historic purposes on archives, and many other questions and opportunities. This regulation has been applied for already 3 years, and I think this is the right time to take a close look whether additional things are needed. We have heard that additional provisions are needed. The technologies are developing rapidly, and new provisions are necessary. We all can participate in these public consultations regarding additional provisions. And of course, we would like to address the notaries and ask them if they have any requests with that regard. The limitation of data subject rights is needed, and from time to time we hear about this. We understand that not all data subjects' rights can be ensured here and now. There are different factors due to which these rights cannot be implemented, but this should be regulated. We have to indicate not only the legal basis, but also the purpose of limitation. There are different cases. I don't want to say that we lack regulation in Lithuania. It's quite the opposite. We need regulation for achieving higher standards. We have good practice in Lithuania. Quite recently, a law on repeated use of health-related data was adopted. And existing laws may be used for positive purposes. And this is one huge step in Lithuania, that we have come to an agreement regarding the processing of sensitive data. There is a need for additional regulation. I am certain that we will hear about many positive initiatives. The practice of other countries and the practice of supervisory authorities promote better regulation. Quite recently, there was a decision adopted by data protection officer that it was illegal to process data for a long time that were not attributed to any specific categories. Now we have to discuss what data retention period is substantiated, for how long the data can be processed. We need changes in this area as well. When the positive experience has the impetus in other areas as well. new draft laws also have impact on Lithuanian legislation. As you know, there is a regulation on artificial intelligence being discussed. It is also related to data protection. In certain cases, very high standards may not allow certain good products to be supplied to the market. Therefore, our agreement is very important. This is just one of the examples that has impact on legislation, including the national legislation. This is an indication of the direction that we have to go to and the standards that we have to aim to achieve. We do not necessarily have to fine everyone who is breaching the data protection regulation, as this regulation only ensures the change of the culture. It allows a more positive developments. Fine has its effect. However, the aim is for the companies to improve their data processing. 46 of the respondents asked said that companies, they wanted companies to be punished, not only improve their practices. People do not aim for the satisfaction for companies to be fined. It is more important for companies to improve their practices. The penal responsibility is not foreseen for all data breaches. Regarding the situation in Lithuania, we see that in terms of sanctions, they are growing in number. However, certain problems are being addressed when using other means, such as reprimands or instructions to improve the procedures. In certain cases, we lack resources. The trust is increasing in Lithuania because the number of notices on the breaches of data processing has increased, and it is growing in number each year. In Lithuania, about 3 million people were affected by data breaches. The cyber incidents are on the rise, and they become more complex. There's lower number of data breaches due to human error, which is a positive development, because we dedicate more time on training, on data protection, on providing the information. The trends are quite positive. However, there's one negative aspect. In 2021, we received 9 notifications about the cases when the information from the databases was leaked. And this is not good, because the personal data of 1 million people have been leaked. And that's why the data protection regulation aims for high standard, because the consequences of data breach can sometimes be felt a year or 2 or 5 years later, not necessarily immediately. There are different types of incidents related to data breaches. Why is it so important to raise awareness about the standards and not to be afraid to say that we are in line with the General Data Protection Regulation? During this situation of pandemics, people have noticed, for example, 40% of people thought that it hasn't changed. 24% of people said that the requirements were not observed more, despite the fact the knowledge about the data protection regulation reaches 74%, and I think this number is really positive. People have their opinion about the implementation of requirements. It has been quite hard to adjust in the past 2 years because we have been working distantly, learning distantly. The employers were collecting certain personal data, and the data protection requirements had to be implemented today and now. Therefore, we face challenges, but I hope that we will manage to meet them somehow. The Data Protection Inspectorate is not attempting to fine everybody. We apply sanctions only in exceptional cases after assessing all the circumstances. In 2021, we have calculated the level of data protection, which was 60%, and it consisted of 4 indicators reflecting the information about data protection, trust, the assessment of infringement, of breaches, and supervision. The program has been in Lithuania, the national program has been adopted until 2030, and we are going to monitor this level in Lithuania, and we hope for its improvement by 10% each year. In certain cases, we see that companies avoid providing specific information, and sometimes we suspect the breaches to be intentional. And in these cases, our inspectorate is forced to imply sanctions for lack of cooperation. Sometimes we see abuse from data subjects because they complain to our inspectorate without talking to data protection officer beforehand. We know about, so to speak, professional data subjects who know the regulation well and who attempt to manipulate the organizations. The most important thing that I want to say is that when a data subject files a complaint, and if you are not working on it, then you have to provide the reasoning for not doing that. Even if the request is not proportionate, you have to indicate why you refuse to process it. Well, I didn't mean to say that everything is bad in Lithuania, but sometimes a few negative examples are followed by others. In the context of data protection, notariate is not the risky sector that is abusing or lacks competences to address data protection issues. We all have questions. And finally, I would like to draw your attention to the mobile application, which is called ADA Gidas, where you are able to inform about the problems, about best practices. We receive some positive notices, and probably some of them are going to be the precondition for inspections. Sometimes when we receive one notice, we have one way to proceed, but when we receive a number of notices on the same issue, we have a different way of proceeding. The learning of data protection officers is very important. And finally, I would like to welcome you all, and I would like to I'm happy to say that you can contribute directly to the data protection. I have looked at the exercises and the tasks that you are going to address today, which are very important. And indeed, sometimes data protection involves other things than high technologists. Sometimes it is enough to lock the door or to lock the screen, the computer screen, and have in mind the simple measures such as passwords. These simple things ensure positive results. So I hope that you will not look at data protection as a monster. We do have a number of rules, but please view it as a possibility, as an opportunity for developing your activities. Well, I hope that the technical problems were not still allowed you to hear me.
We thank the speaker, Madam Morkūnienė, and the timetable, we still have 5 minutes before the coffee break. For our seminar to be useful not only to notarians, but also in practical terms, let us cover the first practical case. You have practical cases on your handouts. Also, I hope that our remote viewers also have their handouts. I will read out the first practical case, and I will cover the possible answers for the case. So, the first case. In the course of electronic correspondence between a notary and a client concerning the coordination of the details of the transaction for the transfer of real estate, a third party has seized control over the email account of the notary or that of the client and modified the content of the client's email by changing the name of the bank and the account number. As you can see, 2 breaches have been made. Seizure of control over email account of a notary of the client, and modification of the content of the client's email by changing the name of the bank and account number in order to absorb financial means. What should the notary do after having noticed that the content of the email has been changed by the third party? Let us begin with a coverage of answers. What should a notary do? First, inform the client about this telephone and this by telephone and ask for accurate bank and account details of the client. The notary should immediately log out of all active email sessions and reset his user's password in the email. And the notary should document the personal data breach in the data breach log. This is the procedure of that the notary should take. In the first case, where it is said that the notary should inform the client about this by telephone and ask for accurate banking and account details of the client, these are actions that a notary should not take, because he could not deny that there was a data breach, and he could not fail to react to it. A second answer: inform the client and the competent supervisory authority. You might think this is the right answer, but we can see that actions like this by notary are not sufficient in this case, and the notary should take additional protection measures to protect and secure his own computer and that and the email box. I can see that it is now high time we had a coffee break. So please go to the coffee break and see you again in half an hour.